Hey, Kevin.
Bombshell.
Well, we'll see. A couple of bombshells today. Thank you for joining me for the Readathon.
Now, we thought we would be talking because this was Trooper Proctor's
Status hearing.
And
that did happen today, actually.
what happened?
Today is July 8th. He has been suspended without pay during the course of the rest of the investigation into his conduct, but more on that later, because that was honestly like the least important thing that happened today.
Which is amazing. Okay.
It is amazing. And I just want to mention one other thing, because I've seen people talking about it on Twitter, and it is true. And I'm talking about trolls on Twitter who are harassing Turtle Boy for not getting the first scoop on this story and being scooped by TMZ. He was scooped by TMZ because he was at his mother's funeral today.
Oh, yeah.
Aidan Kearney's mother passed away of pancreatic cancer. Whatever you think of Aidan Kearney, obviously I have a certain fondness for Aidan Kearney as the journalist of record on this case. Of course, RIP to his mother, and we extend our condolences to him as well. And screw you to the fucking trolls that the first thing that you can think to say is, meh, you got scooped by TMZ. Anyway.
That's kind of missing the point, though, right?
Yeah. Well, I don't know if you saw this, and we didn't really talk about this in the episode we did about online trolling that we put out yesterday. One of the big pieces of disinformation that came out around this case, and you know the difference between disinformation and misinformation, right?
Yeah, sure.
Disinformation is on purpose in order to sway the outcome of something. And I believe a lot of these online people, trolls, bots, sock puppet accounts, the reason they're putting out there what they're putting out there is in order to try to influence a further proceeding, public opinion, etc. One of the huge pieces of information that was put out immediately after the mistrial in the Karen Read case was that the jury was deadlocked 10-2 on the murder charge. You saw that everywhere on Twitter. It wasn't true. I mean, it was very clearly not true. One account started it, a bunch of other accounts picked it up, and that just became fact. It became lore and legend. And, you know, anyone who knew anything was like, no, you're just literally making that up and saying it's true. Well, the fact that that got out there actually ended up being important. Because what happened was, I mean, I think we all expected that Karen Read's team would file motions to dismiss in this case post mistrial. That's not unexpected.
Yeah.
Today, there were 3 motions to dismiss filed, one by her existing attorneys and one by a new attorney that's come on her case, you know, maybe temporarily as an attorney of appearance. But he is a very well-known attorney in Massachusetts named Martin Weinberg. He's a very successful criminal defense attorney and also a great appellate attorney who has successfully gotten some convictions overturned. He's from Boston, went to Harvard Law School, etc. He filed the initial motion to dismiss, and it was followed by motions from Alan Jackson and David Unetti. What happened this morning was online, you only saw those motions had been filed and then not the actual contents of the motions.
Okay.
But hoo boy. When we saw the contents of these motions, the first one that we saw was from Alan Jackson. And here's what Alan Jackson had to say. I'm going to nutshell it for you. Alan Jackson was apparently contacted on July 2nd by a juror in the case, Juror A. Identity, gender, sex withheld because of anonymity processes. Juror A said that they saw inaccurate reports about the split among jurors related to the mistrial.
All right, which was either 9-2 or 9-3 or 10-2, right?
Yeah, the juror was seeing the 10-2 stuff, right?
All right.
The juror was saying they were not happy with this because what happened was the jury deliberations, they unanimously and immediately agreed that Karen Read was not guilty of second-degree murder. It was never on the table.
There were 3 charges to decide.
Correct.
And on one of them, at least,
second-degree murder, the most serious,
this juror says that all 12 voted not guilty.
In absolute agreement.
Or we're going to vote not guilty.
Yes, it was.
Okay.
They were in absolute agreement from the beginning, not guilty of count 1, and they were absolutely in agreement unanimously that she was not guilty of count 3, leaving the scene with an injury or death. Okay?
So second-degree murder, not guilty. Leaving the scene, not guilty. That leaves count 2, which I think is vehicular manslaughter,
Vehicular manslaughter while under the influence. They were apparently split on that one, which is weird.
So that's the count they were deadlocked on.
Right, which is weird because that count also predicates her having hit somebody with her car, which they actually was part of count 3, which they dismissed. Anyway, I'm guessing, and this is just my supposition, that may be, for some people have been like a compromise, you know?
It does kind of feel in the middle.
Exactly. That being said, what this person said to Alan Jackson was that when the jury presented the note to the court, they presented that note saying that they were deadlocked. We had heard by the clerk, by the way, that they were not polled about their being deadlocked.
Yeah.
One thing that I noted at the time that, I didn't say in the podcast, but I did note was that, the judge didn't then go to counsel again and ask. And I thought it was because the Tui Rodriguez rule meant that she had to automatically declare a mistrial. Apparently, she could have asked counsel again what they thought. She didn't. She also didn't say what it said on the jury form.
This is true.
Okay. She also didn't ask the jury on which count they were deadlocked.
Because the first time they had a question, she read the question into the record.
Correct.
Right? And came back in open court and then answered it. And actually read the note to word for word back to the jury and then moved forward. And she did not do that with this note,
correct.
Right?
No, well, she read the note, but she did not ask the jury, on which count are you deadlocked?
Right.
So we don't.
We kind of assumed that it means that they couldn't come to an agreement on all three charges.
Correct. Apparently, they were only deadlocked on one.
Right.
So Alan Jackson's filing says a couple of things. It says, one, that the judge never asked the counsel for consent as to the mistrial. So, that's a procedural error. Two, that if the judge had announced that the jury was deadlocked only on that one charge, then in fact, Karen Reed was declared not guilty of murder by that jury and not guilty of charge 3, and therefore a retrial on murder 2 is double jeopardy.
Yes, right.
So,
charge 1 and charge 3, she couldn't be
charged. And 3.
She couldn't be tried again on those because the jury acquitted her of those charges.
Correct. So he is saying that if the judge had asked that question, then she would have in fact have been acquitted of those 2 charges.
Yeah,
the judge never asked that question. Therefore, the judge basically did not do the due diligence and violated Karen Reed's rights.
Well, one thing that immediately pops to mind, and we talked about this earlier, is that there was an issue when the jury was out about the juror form.
Being incorrect, yes.
Being incorrect and confusing, where it seemed to be that I didn't see the form, but that they listed the 3 charges, but only sort of like the first charge, there was like a yes/no checkbox, and then nothing below that.
Correct.
Apparently, because you're going to get to this about this other filing, words from a juror here, that they found that form confusing.
Correct.
And this definitely could have, because if they had a form where it's yes, no on all 3 counts, they could have turned that back and said, yeah.
Exactly. So the filing by David Yannetti, I think, is even more interesting. Okay. David Yannetti's filing, he hears from informants who spoke to jurors who do not know each other, right? Oh, by the way, Alan Jackson was able to confirm the identity of the juror he spoke to, because he did voir dire.
Yep.
So he has information about the juror that the public does not have.
He's attesting that this is the actual juror.
He knows that it's the juror. David Yannetti has heard from informants who have had contact with jurors, right? And David Yannetti has also been able to confirm through various means, including screenshots and so forth, that these informants did in fact have communication with the actual jurors.
Okay.
He's calling them...
So not hearing from the jurors directly.
Right.
But, okay, so, all right, we won't think about hearsay and that
let's not
stuff,
think about that right now, okay?
Let's get the information.
The information is that 2 different jurors, B and C, so now we're talking about a second and third juror.
Okay.
Basically, that juror B texted to intermediary B. So he has the texts that say it was not guilty on second degree. It was split in half on the second charge. When the judge sent us back with the Hernandez thing, they mean the Tui Rodriguez thing, to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose. They gave us free counseling forms when they left, meaning that it was so rough back there that they gave us free counseling forms.
Here's a coupon to talk to a therapist. The Commonwealth thanks you for your service.
Right. So he's able to say so basically it's like the Tui Rodriguez thing turned it into a melee back there, okay? So that's the first piece of information.
Right, I saw something that before that they were 6-6 on that
that's
charge.
Coming up.
Okay,
that's
go ahead.
So that's juror B. So juror B had to say.
Yeah.
Juror C is even more concrete than the information about juror B. Informant C tells Yannetti that personally knows juror C. They used to work together. They also have a mutual friend who currently works with juror C. There was a Zoom call with juror C, in which the following information came out. And there's text messages that are again sent to David Yannetti. No consideration for murder 2. Manslaughter started polling at 6-6 and then ended deadlock in 4 no and 8 yes. The juror was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, they voted no because the cause of death was twofold of hypothermia and head injury, and of which was convinced the vehicle did not cause both. The whole jury felt intimidated by Higgins' presence at the end. Now, Higgins, they don't mean Higgins. They're confusing the two Brians. Brian Higgins and Brian Albert.
Okay.
Brian Albert was present during the closing arguments when Paul O'Keefe invited Jen McCabe, Colin Albert, and Brian Albert all sitting there during closing arguments staring at the jury. Witnesses in the trial that the defense was alleging were part of a conspiracy staring at the jury and sending the signal.
That's such a weird seating setup.
I got to tell you, though.
Yeah.
I don't know what the rules are in Massachusetts or whatever. I believe it was improper for Bev Cannoni to allow those witnesses to sit there looking at the jury with the family.
Well, I think they could go to open court, but the way the setup is, you're right. They're just like sitting...
staring at the jury.
If you can imagine the TV courtroom that you always see and you have the jurors on that panel on the side, imagine another panel on the other side of the room, but that's like seating for the general public. So they're directly facing the jurors.
Right. And have you seen Brian Albert? He has like resting intimidation face. I am not kidding. I mean, I'm not saying that lightly. I think he was a Marine or something. He literally has like resting intimidation face.
Sure.
All right. So the juror's not sure what they're going to do. They're going to lay low for a couple of days and see where it takes them. They haven't ruled out anything. They all have a group text going.
The jurors have a group text.
Oh, absolutely. They all have a group text going. Okay. So basically the juror felt honored to be a part of it. Everybody was from a professional walk of life, different. They all got along. It's the way it should be. They'll be studying this case in law programs for a year to come. They all agree on no for murder 2. They should make it clear to the DA in the court that it's a case of double jeopardy if she is retried on that charge.
Informants, this is one line I'm just pointing to there. This is what a great experience. This is the... Okay.
Yeah, you hear what it says?
What a great experience for him or her, the juror. Amazing that they let the Alberta, and I think the Alberts in the last day. So another... Yeah, okay.
Another reference that was very strange, right?
Again, not directly from jurors B and C, but these are people that they have communications from. And
correct. They were present on the Zoom calls and so forth.
If this were the only thing, then you might... Hearsay, but it seems
it's
to
so
back up what
with juror
A said.
Yeah.
And it'd be so easy to find this out by calling back the jurors.
Yep. Absolutely.
Wow. This is explosive.
Yes. Meanwhile, Bev Cannoni's on the Cape shopping for groceries. By the way, it's so funny. Bev Cannoni is like a celebrity now, being photographed everywhere. So yeah, who would have thought that Michael Proctor, being suspended without pay would be like the least interesting that happened today? Obviously, there's more to come here. I just wanted to explain clearly what is going on. I can't interpret it. And by the way, Yannetti is a Massachusetts lawyer. So one might say that Alan Jackson doesn't know Massachusetts law. This whole idea of, potential double jeopardy makes no sense.
Well, that's why you have local counsel on that. And that's what he serves as.
Is a lawyer they're both admitted to the bar in Massachusetts, but Yannetti is a lawyer who does cases in Boston all the time. I believe that Yannetti understands sort of the ideas and processes and what is within and outside the bounds of Massachusetts legal theory, right?
Yeah.
So this is interesting, and we are going to be following this in depth. I honestly thought this was going to be a mellow read week.
Yeah.
Yeah, fuck that.
Wow. I do not see how one can argue that is not that is a harmless error.
It is not.
A harmless error on the part of the judge.
To not ask the jury. I mean, she said, I'm going to come back and talk to you after. She did not ask them in the courtroom, on which charge are you deadlocked? There were 3 charges.
Yeah. And I think, yes.
So there's so much more to talk about, Kevin. I'm just going to drop a couple of spoilers. Another thing I want to tell you about.
It's funny because that juror note was pretty
Look at you.
articulate.
You're so stuck. Yeah.
No, I mean, it was so eloquent and articulate, but it's missing a certain detail.
Yeah.
Which is to say that we are deadlocked, is that we are... we cannot come to agreement on all we come to agreement on some, but not all charges.
Well, Bev read the note. We haven't seen the note. Bev read the note, right?
Yeah, could have paraphrased. Could have.
We don't know. I mean, I'm not saying that she did that. Who knows? It's just like at this point, I don't fucking know.
The jurors know.
Yeah, but at this point, like, I just don't know anything, right? I thought I knew stuff, and it's just... All right, so spoiler alert as to one other thing I want to talk about later this week. This, of course, is one of the most interesting online things that's popped up during this trial is this visualization account that the defense was working with. Apparently, they were going to show a bunch of their visuals during closing arguments and couldn't because of the closing arguments being limited to an hour. But there's this firm called Microdots.
Yeah.
They're the ones who've made all the visualizations of the absurdity of some of the theories and have made visualizations of what it looks like when Lucky's plow is going on the road or whatever. Microdots has a very interesting new set of visualizations about Jen McCabe's phone calls and timelines, etc. I do want to talk about that stuff because people on the web are talking about it. I have looked at it. My feelings about Jen McCabe have definitely evolved in recent days. I went back and rewatched her testimony. And I want to talk about that later this week. We'll talk more about Michael Proctor. But this news, I couldn't not talk about only this today. And we've gotten a voicemail. We've gotten some other stuff that we'll be talking about also later this week. So anyway, if you do have thoughts, comments, questions, please, send us a voice memo, record it on your phone, send it to us at crimewriterson@gmail.com. We might play it on the podcast. We'll answer as many questions and play as many comments as we can. That's great stuff that we love doing, engaging with you guys, our listeners. And Kevin.
Yes.
Thank you so much for joining me for this breaking edition of the Readathon.
Oh, yes, you're welcome.
Partners in Crime Media.